If you or your spouse does make an application to the court to resolve your financial settlement, if say there's a dispute or you've just not been able to reach an agreement, the court will set the timetable for dealing with the case. And that typically follows a 3-stage process. And it can take anywhere between 6 to 18 months. Firstly, the court would direct you and your spouse to complete a document called a Form E. They would also make a number of other directions that you and your spouse have to comply with ahead of a first court hearing, which is called a first appointment. And in this 3-stage court process, there is 3 separate court hearings. The first one, the first appointment, is generally scheduled around 3 months after the date on which either you or your spouse has made the application to the court. And I refer to it or describe it as a case management hearing. So the judge at that first court hearing, the first appointment, their role is not to make a final order about how the finances should be divided. Their role is to manage the case. Their role is to check if people have done what's ordered of them before the hearing. So have Forms E been completed? Have people filed valuations for the family home? Have they filed evidence of their mortgage raising capacity? Have they filed, for example, property particulars? The other important role of the judge at that first court hearing is to set directions for dealing with any disputes about the value of an asset. So let's say there's a property and you believe it's worth £200,000 and your spouse believes it's worth £250,000. A judge at that first court hearing, if invited to, can, for example, direct and order that a chartered surveyor shall be instructed to undertake a valuation report of that property. And that is how the court would then resolve that dispute. There might be other issues. There might be a business that needs to be valued, or there may be pensions that need to be valued. And the judge at that first court hearing can deal with those issues. At the end of the court hearing, the judge will typically set a date for the second court hearing. The second court hearing is called a financial dispute resolution hearing. That could take place 4, 5, 6 months after the first court hearing. It really depends on how busy your local court is. The role of the judge at the second court hearing is to give you his or her view as to how your finances with your spouse should be distributed. So it's their opinion, it's their indication of what the financial settlement should be. Importantly, as with the first court hearing, the judge can't make any final orders about the financial settlement. Their role is to try and encourage you and your spouse to reach an agreement, having heard the judge's opinion, their indication about what the financial settlement should be. Normally people listen to it, reflect on it, and there's a period of negotiation. And in my experience, around 70% of cases settle at that second court hearing. If you're not able to reach a settlement at that second court hearing, then the judge would schedule a third court hearing, which we call a final hearing. Again, we would have to wait for that third hearing, and you can see the span of time already. But at that third hearing, if we've not been able to reach a settlement along the way, the judge's role is to make a final order, is to make final decisions about how your finances should be divided.